Hello, my name is Jay Fuller. I'm one of the attorneys at the Fuller & Fuller Law Firm. We handle injury cases throughout the state of Washington. Well, I wanted to talk today about the topic of defenses that the insurance companies can use to diminish or defeat your claim if you have an automobile accident and want to present a claim for damages. And there are many, many defenses that are used by the insurance companies to limit or perhaps even defeat your claim. But I wanted to discuss two in particular today that I see crop up quite often in my practice. The first one is where the assertion of the insurance company is that you have sustained a prior injury and had prior treatment to the very area of your body that was injured in this particular accident. In other words, you have what they call a pre-existing condition. And the reason that this is important is because in some cases, insurance companies use this factor to try to not pay full value on your claim. They essentially assert you were injured. For instance, let's just use a person's back as an example. If they had a prior back injury, they would say, well, you had injured your back before, and you had had treatment before the accident. Thus, the fact that you injured your back this time results in a situation where they should not have to pay full value for your claim. Well, there are two sides to that coin, and as I mentioned, the insurance company essentially says that they want to diminish your claim because of your pre-existing condition. But in the state of Washington, the rule is that if you have a pre-existing condition and your physician says that this pre-existing condition has been lit up, or the technical word is exacerbated as a result of this accident, then you can use that medical evidence from your doctor to present your case and show the new aspects of your injury and the fact that there are new symptoms and that your condition has been made worse by the fact that you have been in an accident. So those are some things to remember when they claim that you have a pre-existing condition. The second defense that I see raised all too often by insurance companies in cases where I represent people in automobile accidents is what's called a gap in treatment. Now, a gap in treatment is a situation where, for instance, a person might have been in an automobile accident, they were injured, and they went to the emergency room. But even though after their visit to the emergency room on the day or the day after the accident, they may still be hurting and may still feel in pain, for some reason they decide to, as I put it, tough it out. In other words, instead of receiving medical care, they decide to grit their teeth and see if the pain will go away and see if the discomfort will go away. Well, this is a bad idea for a couple of reasons. Of course, it goes without saying that an untreated injury becomes worse over time without medical attention if you just let it go. The second part of it is, as far as your claim is concerned, the insurance company might assert that there is a gap in treatment. In other words, that you must not have been too severely injured because after you went to the emergency room, it was a number of weeks before you ever went back to the doctor. That's why if you truly are hurting and were injured after an accident, it's important for a number of reasons to get medical care as far as documenting your claim and getting the assistance of a doctor. Well, both of these defenses that I've mentioned today are important also because it shows you that you have to be very wary and very cautious when you're dealing with the insurance adjuster from the opposing insurance company. In other words, the insurance company representing the interests of the person who caused the accident, the person who hit you. For instance, they may call you and ask for a recorded statement. Just remember that you're giving them a recorded statement, they're the opposing adjuster, and they may be seeking information that will assist them in presenting either of these defenses or some other defense. The other thing you should be cautious of is when the opposing insurance adjuster calls you or sends you in the mail a waiver of medical authorization. In other words, that they have permission and you have to sign off on this, to look at your medical records. Be very, very careful and think twice about signing that particular document if that's sent to you by the adverse adjuster, because remember, they will then be able to look at all your medical records that are covered in the waiver and the medical authorization that you sign. And in addition, they will then be able to contact your doctor directly and discuss your situation directly with your physician. Well, I hope these examples of defenses have been of assistance to you. And once again, thank you for listening. My name is Jay Fuller from the Fuller & Fuller Law Firm.